as much as I would love to represent her, she is too much of a rock star for me to feel virtuous.
Okay, so we have two panelists who should be joining us, but we'll start nonetheless in the interest of time. Our topic today is, should arbitrators be worried about being replaced by AI, emerging threats and opportunities? So allow me to start by saying that while I was preparing for this session, I read the Forbes 2018, which gave me an insight on how AI is transforming the world and ADR. So in the Forbes 2018, they declared that we are at the cusp of the fourth industrial revolution. And it said that this particular one was going to be unique because while the other ones, we relied on water and steam and electric power and information technology, this particular one was going to be based on AI. Now, the panel before you is going to discuss how AI has impacted alternative dispute resolution. We're going to have the team talk about why ADR has become popular, how AI has been used to advance ADR. So I'm going to start with Lady Justice Monica Mugenyi. I hope she's online. Please let us know if you can hear us.
Yes, I can hear you.
Oh, thank you so much for gracing us with your time. We do appreciate the time you've given us. So we're going to start with you.
Apologies, I had to leave, but I hope I can make it up online.
No, I think your presence is noted, and we do appreciate that you're making that. We do understand that you have a very busy schedule, and we do appreciate your time. So we're going to start with you, Lady Justice Monica. So the question I'm putting to you is that ADR over the last 30 years has garnered popularity. And it's clear that with the growing institutions, specifically in Uganda, we have ICAMEC, we have KEDA, we have Praxis, to mention but a few. In your opinion, as someone who has ADR background and qualifications, what, in your opinion, is the reason for this growing interest in ADR?
Thank you. I'm sorry I didn't get your name.
My lord, my name is Nora Kagwa. I'm the registrar at ICAMEC.
Okay, thank you very much, Nora. ADR, as we know it today, is not only arbitration. It goes back to negotiation, where two people sit and decide to resolve their dispute through a discussion. It includes mediation, where a third party brings the two parties together and tries to help them work out a solution. It does also include, as an offshoot, a neutral sitting with two disputing parties and trying to get them to appreciate the pros and cons of each of their cases. And then finally, ADR includes a mini trial. And a mini trial really is a neutral sits with the executives of two companies, if they're companies, and somebody takes both parties through a snapshot of their cases to give them an understanding as to what their odds would be if they went to full trial. Finally, of course, the most emblematic or the flagship of ADR is arbitration. So those, in a nutshell, are the types of ADR that we know today. When you talk of 30 years back, we're looking at the advent of e-commerce. And as businesses tended to want to operate in as optimal and expeditious manner as possible, e-commerce took root, and with the advent of e-commerce came up a search for dispute resolution measures that can match up with the expediency of e-commerce. And therefore, we saw simple things like negotiations that are facilitated by emails and WhatsApp groups with time, and simple discussions where you didn't have to write letters to get in contact with disputing parties. So in a nutshell, what we saw were two generations of AI. The first generation was a lot simpler. It simply entailed bringing two warring parties into contact, And once they were in contact, a third party, probably a mediator or an arbitrator, came in to help them resolve their dispute. But the initial contact was facilitated by simple technology like emails and WhatsApp discussions. And then after these were out of the way, a third party came in. The second aspect of that is what in the judiciary we have as exmis, where you have e-filings and e-payments in their simplistic form, but the actual dispute resolution is reserved for the courts. So in terms of ADR, we have systems, for example, I think there is a system called e-arbitration that I just came across today. Somebody sent me something trying to enroll me onto a platform called e-arbitration. And this e-arbitration does the same thing. It provides for e-filing for arbitration. It provides for e-payments. It provides for e-filings of the documents. And then ideally, which I shall come to shortly, ideally there should also be electronic allocation of these matters to arbitrators. But I'll point out how problematic that is in a minute. And then finally, we have digital signatures. The arbitrator has an e-hearing, electronic hearing, and then concludes his award and signs it off digitally. So that's the simple first generation of AI. The second generation, which sometimes is called the blind model, is completely automated. There is an automated agent that totally does away with human intervention. Whereas in the first generation, there is some limited human intervention. In the second generation, we have either minimal or no human intervention at all. And what are we talking about? Again, of course, you have the e-payments, the e-filings, and this is in arbitration, which is more formal. E-payments, e-filings, e-hearings, and then the digital signing off, and it also includes the electronic allocation of arbitral cases to arbitrators who belong to a platform of arbitration of arbitrators. And in my view, while I'm giving simply a broad perspective, for me, what I would flag out is the idea that a platform somewhere feeds in the facts of an arbitration and then electronically designates the arbitrator goes against the basic concept of arbitration, of choice of arbitrator. That's a fundamental aspect of arbitration. So once that is done away with, I am not sure we're still looking at arbitration as we know it, or an offshoot of arbitration. So in a nutshell, for me, it's the first and second generation artificial intelligence interventions that have led us to where we are today. They both have their pros and cons. I think the first generation intervention is very practical and useful for negotiation and mediation, which are less formal, because you can get the parties to get in contact with each other, and then through shuttle diplomacy, a mediator liaises between the two parties to get them to an agreed settlement. When it comes to the more formal arbitration, where there must be a thorough understanding of the case before an award can be made, simple things like what remains unstated by the disputing parties. There are what are pleaded, and then there are matters that can only be picked up when evidence is brought, witnesses appear before a human person who will then, through observation, pick the nuances and the unstated issues that are not necessarily reflected in the pleadings, but might be the deal breakers. So what often happens with such an arbitration, if an experienced arbitrator realizes that the issues in the pleadings don't quite address the underlying and fundamental interests of the two parties, they could refer the arbitration state and refer it to mediation so that this fundamental issue comes out and parties are brought to an agreed settlement. So this is what we call the mid-up, mediation stroke arbitration, or arbitration stroke mediation, whichever way you want to look at it. And that sort of possibility, that sort of flexibility is killed by pure automated intervention without any human engagement. So these are some of the pros and cons I can think of offhand of pure automated AI without any human intervention whatsoever.
Thank you, my lord. And I do know that you have limited time, so we'll go right to your second question because I was informed that you won't be staying online for long. So just to transition from where you are, having had a background in ADR and and litigation and the court system, what, in your experience, made it easy for ADR to transition to online during lockdown? We saw very many arbitral institutions and arbitrators easily navigate COVID because they were able to transition to online. What, in your experience, made it easy for ADR to transition to online ADR and online platforms?
I think the salient feature of ADR, all the aspects of ADR, whether it's negotiation, the whole range of them, the salient feature about them is their flexibility. When it comes to litigation, you're bound by a certain set of rules and you must work within there. Of course, arbitration as well, if you go for institutional arbitration, you might be bound by certain rules or the administrative structures of the institution you submit yourself to. Or even if it's ad hoc arbitration, if you choose procedural rules, you may have to operate within there. But in terms of the actual conduct of the arbitration, you have flexibility. You can simply say party X by email, something that can't be done in court. You simply say by email, I'm instructing the parties to file their pleadings in this manner and send an email out to each of them. Or I'm saying we're going to conduct this arbitration in 2 days instead of the anticipated 1 week. Or we'll have parties address us only on specific issues that an arbitrator has identified, which are things that happen in the traditional court system, but the formality within the court system would have impeded some of the work that was accomplished during COVID that we might not have been able to accomplish if it was the formal court system. So I think that's why ADR in particular benefited tremendously from the availability of technology, from the availability of legal technology, and the possibility of drawing from these processes to incorporate them into this flexible and dynamic dispute resolution mechanism.
Thank you so much. Thank you, Lady Justice Monica Mugenyi. We do understand that you may have to leave us, and we do appreciate your time with us. I'll move.
Thank you very much. I'm sorry I have to leave because I'm coming from another conference and it's been a long day.
Thank you. No, we do understand and we do appreciate your time. Thank you very much, my lord.
Thanks very much.
Okay. Thank you. I'll move on. Like I said, we only have a very limited time, so I may have to limit the number of questions that we put to our panel. But what I can ask is that if you do have questions, you can write them down and give them to the Law Society team, and they will share them with our panel, and they'll be able to send you the answers. So, Olivia, just coming from what Lady Justice Monica Mugenyi was saying, with the rapid advancement of AI and technology, many in the legal profession are contemplating the impact of AI on ADR. As someone who has a background in negotiation, mediation, and arbitration, what impact, if any, do you see that AI is having on ADR or will continue to have on ADR?
Well, thank you, Nora. Good afternoon. I think ADR operates in a spectrum of the business community, and indeed we see that other businesses have embraced AI in terms of the way they run their businesses. So just before I go into the impact, just to give you a sneak peek, I think a few years ago PwC issued a report to speak about the impact of AI in businesses and predicted that by 2030 AI will be contributing about $15.7 trillion to the global economy. And as such, many players in all other sectors were embracing AI. So as ADR practitioners, it's also a business or an industry that must embrace AI and take on its benefits. So AI is something that would assist in the dispute resolution process, especially if you look at the advantages, and I think some of them the Honorable Lady Justice spoke to, in terms of filings, for example, eliminating the human contact, and then the trouble with bulky documentation, because especially arbitration, you find that most international arbitrations have bulky documents involved. So with AI involved, so that process is automated, and then the system is able to organize the documents in a way that the arbitrator or the tribunal will easily deal with them. And then the system is able to also review and analyze, for example, the different documents that are relevant in terms of their order for the decision making. And obviously through that there's efficiency. But in addition, you'll find that with artificial intelligence, you'll have transcription. Instead of having a human having to transcribe, then you have a machine that is transcribing the proceedings in real time, and the parties are able to get the information in real time. And obviously also in terms of updates to the parties, in terms of assistance to the arbitrator and the parties involved, you find that there is a quicker way. You'll find probably chat rooms where parties can quickly get information even if the human arbitrator is not available. So I believe that AI is one that has to be embraced. But in terms of whether we can have a robot actually arbitrate a dispute in terms of issuing an award, that is a conversation that has to go on, because as Justice talked about, each case has different facts. Now machines will learn a particular pattern, and probably they'll issue a decision depending on that pattern. I remember in law school, we used to have those summaries where I would have, it was held, and you'd only speak to a principle without relating to the facts of the particular case. That is the same thing that would happen with the robot. The robot will not look into the special circumstances of each case and then give a decision based on that, but it would look at the general principle, what has been said, breach of contract, and look at principles on breach. But as to the facts, whether there was indeed a breach or not, may not be able to differentiate that. So I think those are some of the challenges that may happen. And then obviously the other challenge might be the issue of security. We know with technology there are issues like hacking, and the backbone of arbitration or ADR is confidentiality. So where the system would be hacked, then there's a very big challenge there in terms of the privacy, and also in terms of legitimacy of any awards that may come out of such a system. So as we embrace AI, those are some of the questions we must ask ourselves. How far must we take it? To what extent? And what protocols must we put in place to ensure that the system is secure and provides the level of confidence that the participants would want? Thank you.
Thank you, Olivia. Giora, thank you so much for joining us. I know that you have had a few panels today, but we do appreciate you coming to our panel, even when it's this time in the day. Please don't get too tired, not yet anyway. So just to follow up on what Olivia has said, and what the Lady Justice pointed out, the human aspect, right? We have heard of digital mediators and digital arbitrators, right? Now, the human practitioners have abilities to interpret non-verbal cues. Like if you're a mediator and you have parties before you, you'll be able to look and say, okay, so there's something here, maybe this one's uncomfortable, just by looking at the parties. So the emotional intelligence, the flexibility, the adaptability, or even the craft to be creative and come up with solutions in real time to meet the needs of the parties. Can it be said that the digital mediators and digital arbitrators would be able to have the same capabilities?
Thank you very much for your questions. It is a pleasure to be here, and I apologize for being late. I agree with my fellow colleagues here, with the Lady Justice and Olivia, the points that were made earlier. I think there are a couple of things that are worth noting. Back in 2017 and 2018, I know that Harvard did a study on how digital adjudication could be, not in a context of arbitration, but in a context of potentially using AI, for lack of a better word, as an adjudicator. And the models that were available back then were based on the models that essentially allow AI to assess given information based on the predetermined set of facts, right? So since then, obviously, there's been quite a lot of developments in AI. That being said, majority of commentators still are reluctant to say that it would be possible to fully substitute, human element when it comes to especially adjudication, right? I think that I think there could be a lot of potential to help arbitrators and mediators in assessing documents, in reviewing materials, in preparing for the hearing or for the international hearing. But when it comes to actually deliberations, I can hardly imagine how deliberations at this stage of development, right, with the models that exist right now, could be completely digital. I think the human element is essential during the deliberation. That being said, I think AI could learn quite a bit if the models were improved and we looked at the ways the deliberations could become more efficient. I think there is an interest for the clients in that because the process of preparing the final award could become shorter and more efficient, so the clients would not be complaining that the arbitrator take a very long time to actually draft up the award. I also think that this process could be further improved, by the members of the court. I serve as a member of the court in several arbitral institutions, and when we scrutinize the awards, I think there are certain ways how this process could be improved using AI, which again, not to substitute the role of members of the court or the process of scrutinization, but really to streamline it, to make it more effective, to increase the possibility of no errors, for example, and allow AI actually double check information that is already decided. And I think the work product in the end could be better. It will be better. It will be less subject to potential set aside by the domestic courts. I think it will also give certainty or certain level of comfort to judges, because as we know, the functioning arbitral system is the one where we know that we can rely on the courts, right? I mean, in the end of the day, it's the judges that enforce those arbitral awards. So I think for judges, it's always the question of how can we comply with our own regulations, especially when it comes to commercial awards that are enforced under the New York Convention, because a lot of deference is given, of course, to the judges. So I think that element of having the award triple scrutinized, for lack of a better word, could create, right, because it doesn't exist yet, a certain expectation of accuracy that could be comforting in the end of the day. But that all being said, these are the things that we can improve, but it's by no means how I can see adjudicators, right, or arbitrators, mediators actually being substituted in the process, because as you've rightfully pointed out, it's those details, right? When you observe someone being cross-examined or answering questions or counsel answering questions during the hearing that really concern you. And we've noticed that, I think, even during the COVID-19, with the remote hearings, that it's already difficult enough to really assess cross-examination when it's done remotely. I don't know if you had this experience, but I found it very difficult to cross-examine witness remotely because, it's really difficult to catch the witness because they feel more protected. There's a screen between you, and when it's in real time, I think the process is much more fluid, and there's there's an exchange, and there's certain ways how the witness or expert reacts that speaks volumes to the arbitrators. So I think that being said, we can see how anything not in person when it comes to the action time, right, of the hearing could really contribute to the outcome when it comes to the merits hearing. So if this is the case, I think we're far away from adjudicators or arbitrators or mediators being completely substituted with the progress in the digital technology, which in no way I should note should be disregarded, because I think it could really help us. It could really make our final work product better and more excellent. Thank you.
Thank you for that. For those in the room that are interested in becoming neutrals, whether arbitrators, whether mediators, you still have time, according to what she has said, because AI is not going to replace us just yet. It can facilitate us, but it's not yet going to eliminate us. So there's still time for some of us. Maybe what, 5-10 years?
Well, it's hard to say, really, because I think that AI is developing quite quickly. I mean, even as we look at how the quality of product has changed in the last 7, 8, 9 months since it became available to public. So it's hard to make the assessment. It could be much less, but I think we will be seeing fairly soon how the arbitral rules revised to allow arbitrators to utilize AI. And I think to the extent you're interested in participating in it, it's good to just be aware of what's happening in the industry. But in terms of full substitution, I'm not sure even in 10 years it would be possible, frankly. I mean, the risks, I should add, the risks that were found in that study in 2018 by Harvard is that the risk of the judgment that could be not fully fair, right, or consider all due process considerations to the parties is very high if you're using the AI to determine the outcome of the dispute. Of course, we are not using it in a criminal context. We're using mostly for commercial matters, right? Mediation, arbitration are used in commercial matters, but still, I think. Just think about how many set-aside proceedings could be happening if AI fully takes over. I mean, in the end of the day, it's like AI to determine arbitration or mediation, but then when you go to the courts, if the judge is reviewing that, assuming the judge is not AI yet, like then it's just a domino effect that that's already problematic.
Thank you so much. Robert, I'll move right to you. They've mentioned several advantages to employing AI in ADR. But they've also highlighted on the potential risks and concerns that we should be mindful of. What, in your opinion, are the risks and concerns that we must have at the back of our mind as practitioners and neutrals in this area?
Thank you, Nora. I think that Diora and the other panelists have covered some good ground on that. Let me just add maybe 2 major ones. So the first one is something called overfitting. The way that AI is built, sorry? The sound seems to be...
Yeah, the sound seems to be off. Sorry?
Okay, so I think that I can try and project. I used to have dreams of being a rock star, so maybe someday we'll get to it. So let me just perhaps add 1 or 2 risks to the excellent conversation we've been having already. And the first one is something called overfitting. Now, overfitting is where you're basically saying, okay, AI by its default nature is learning from data as it consumes it continuously and adjusting the models variously. So if you take the same algorithm that determined Muhammad Mbabazi versus Robert Chirunda and you apply it to the next dispute, it's going to take some things it learned from the patterns of this data and potentially apply those lessons to the patterns that it's picking up from this other data set. That's problematic because you're dealing with risks in one dispute that are framed out of the conduct of 2 very different parties, and you're potentially exposing those biases to a different dispute. Now, I think we can see where that creates a problem. So in addition to not having been able to read the cues from the human nature, incidentally, a really excellent book that I came across years ago on AI, is by a man called Kaifuli, AI Superpowers. He talks about the contest between the US and China. What I loved the most about that book is the conclusion. In an AI-driven world, what will really make this world worth living in is our very nature of being human. So it seems we're going to go full circle to enjoying all the benefits of AI. I mean, think about even today, if you use Firefly, you can generate a transcript in real time. Teams is doing that for you now, literally for free. And that is AI. So the benefits are there. When you take it to where, and by the way, I believe that we're going to have judgeless adjudication in less than 5 years. So I would put the horizon less than 5 years. The thing to think about, though, is not, if we replace humans, should we focus on the risks? I think that's the wrong way to do it. I think what's going to happen is that we will repurpose the human element. So if I built a model today, I would be using the humans to pick up those risks and adjust the models until I get to the point where I have a functional model. Google today is 1,000 times more functional than it was in 2005. Why? Because they're constantly improving. Can any of us honestly, genuinely say, regardless of what you think of its founders, that you can live without Google? If you think about that for a second, the day will come when, as attorneys, we cannot live without AI-made adjudication. The other risk, the really large potential one is, so when we discuss risks, it's easy to look at the very specific detail as opposed to stepping away from it and looking at the larger implications. What is the possible problem with that? It's going from legislation to how we're writing the rules to how we're applying them. I think the rules we will use in that world are different from the ones of today. So rather than writing the rules to accommodate AI, we should be thinking from an AI perspective outwards to what should the rules actually be. Because I think that the world of OIR will require its own legislative model that's different from what we have today. That's where legal design becomes a critical element. The problem with legal design is that it's being engineered now by non-lawyers, mostly. So you have geeks writing rules for lawyers. And so they don't understand what it really means to be an attorney. I keep telling people, a young man came to me once and said, represent my father. His father is a well-known convict in this country. He was involved in a huge scandal at the OPM. Let's stay out of names, but I'm sure every Ugandan in this room knows who exactly I'm talking about. And he said, but my dad does all the work anyway. You just have to come and he will even give you the submissions. I told this young man, don't you ever say that to a lawyer again, because you have absolutely no concept of how many things could go fundamentally wrong from the point when I say, may it please the court, my name is Robert Chirunda. From that minute, whether Dr. Noria stands up and says, my lord, before we start, I have an objection. Things could go wrong. Here's another one. When we step into the space itself, in an adjudication, an arbitration, away from picking the cues and whatnot, there is the idea that I should have the opportunity to introduce new evidence mid-trial. I can make an application then and there. I cannot do that with an algorithm. The algorithm takes the data you feed into it at a particular time, processes it, and spews out a result. Now, how do we accommodate that fluid nature of a hearing? How do I object to a document being tendered mid-process? So there's the practical aspects of it. But I think what's going to happen is that geeks and engineers who need the law for other purposes will figure these things out. It would, therefore, in my view, be a bit unwise to step back and say, will we be replaced? I think what will be replaced is not us, it's what we do. So what would then happen, for example, if I was building a judgeless arbitration house, what I would do is retain individuals and just cut the cost. If you think about it today, an ICC arbitration could cost you as little as $12,000. I'm doing one now where an application, a simple application that should be determined in 30 days, the fee has been quoted as $12,000. If I came here and said, guys, I need to recruit 3 people, I have 3 slots, and the condition is you should agree to edit documents for $1,000 a document. So whether that document is a submission, authorities, or evidence from one side, or the actual award itself, if it's $1,000, it's going to be much cheaper than a house that's charging $12,000. Now, the individual becomes the backstop to that, to say, okay, the algorithm has said, but is this correct? And once we do that over time and the models can produce final results, then I won't actually need a person with an LLM from Harvard, an SJD from Stanford, and a Bachelor of Laws from Makerere. Did I mention the second LLM from Cambridge? No, I don't. I actually need someone who can read good English and compare documents. And if you think about it, there was a time when every law firm in this town had a secretary. Now I think we would struggle to find which ones do have a secretary. You know, and 5 years from now, I think that's what arbitration actually looks like, because mainly of one of the core principles, which is party autonomy. If I say to you, these are the risks, you choose to enter this house knowing these are the risks. We have done our best to mitigate against them, but they exist. And you come in, you will discover that rather than 6 months at CADA or 1 year at ICC, this house is taking 15 days to 30 days. If you're a bank, what would your choice be? Because let's not forget, one of the major advantages of the court system is that Lady Justice is depicted as being blind, but not heartless. So we like the human touch. But at the same time, money is blind. Commerce, by its nature, is blind. It doesn't really care about sentiment, which is why, as a lawyer, you represent the bank and you actually sign the advert that leads to a foreclosure. You're putting someone homeless on the street, you've got to do it as much as you feel for them. You've got a client to please. And the day will come when, as we democratize, you talked about 4IR, if we're democratizing money itself, we will democratize justice. So for me, from where I sit, the risks are huge, but one is unwise in thinking they are insolvable. Because I think if we could split the atom, if we could put a man on the moon, we'll figure out how to because you see, what we also forget is AI is becoming sentient. The debate around whether Google's AI is sentient tells you the day will come when sentient AI is a reality. And when it does, everything we've just said about sentimental aspects of a trial will be possible. I think 2030 is far. But then that's just, again, my reckless thoughts.
So we had hope, then he destroyed it in 3 seconds. Thank you for that.
No, but Nora, let me just emphasize this. The key is not to think about ourselves as being replaced and cast out of the room. The key is to think about ourselves this way. How will we adjust? If I may just mention, Dr. Nora supervised my dissertation at Bachelor's, and I'm incredibly proud to share a panel with him. When we were doing that work, we saved my thesis on a floppy. You know what backup was? You saved on 6 floppies because one could crash. Today, I have a phone that has more space than my laptop. And the two of us are still here.
And you back up on cloud.
And I still refuse to back up on the cloud, but Muhammad just pointed that out. You know, I've resisted, but I cannot help it. Because the guy selling me the phone says, oh, by the way, you have free cloud space. It's actually silly not to back up in the cloud. As unsafe as it is, we do it. So I think the goal is to think about, what will tomorrow's lawyer do? We worry about AI because it sounds grand. Step away from AI and just come to URSB, document registration. URSB has actually fired all the clerks in our offices. By virtue of the fact that the client can upload their resolution from their bedroom at midnight, we've actually been replaced. Just because it's not AI, we're not talking about it. But the truth is, when we left law school and we enjoyed putting at the bottom of the resolution drawn and filed by, and that was a legal requirement, that's gone. What's the result? Why would clients actually embrace it? It cuts their cost because they don't have to pay you 500,000 shillings for a resolution, which is about $150. They don't have to wait for you because you're very important and they can't get an appointment. And you know what? You don't have a choice. You have to think about, because there's an aspect of the company law they cannot argue with, which is, who can read section 145? They can't. They still have to come back. But at the same time, you and I know that if we've been replaced out of URSB, we've got to find another way to get back in. And we will by the end of the year. So just because that's not AI, it's not such a hot topic. So if you flip that on its bottom and say, what will I do when AI is mainstream? Then you will never get replaced. And that's what Google does best.
So we were happy, then we were sad, now we are happy again, right? So, Mr. Muhammad, give us an idea of how these platforms actually work, specifically online dispute resolution. How does it actually work? And if I'm a practitioner who's considering embracing it, what do I have to know? They've highlighted some of the risks and the challenges that we might face as practitioners if we don't adapt to it. But what do we have to know about, for example, specifically online dispute resolution?
Thank you very much, Madam Moderator. Thank you so much, fellow panelists and members of Uganda Law Society. I'll begin with a quote. It says, "The lawyer will not be replaced by AI. The lawyer will be replaced by another lawyer who has tamed the power of AI." So I will not go into what AI is. I will not also go into what disruptions have been caused by AI, because my fellow panelists have talked about them. But when we are talking about, I think the Lady Justice talked about ADR, we're now talking about ODR, online dispute resolution. And the Lady Justice talked about it. But for our purposes today, I would be talking about that autonomous arbitrator. Not automated, but autonomous. Like this other car we've heard of for Elon Musk, which they call it driverless. So can...
Tesla.
Tesla. Yeah, but it is by Elon Musk. Is the one who, so can we get to that stage? I think there is something they have said we can get there. And I think in some jurisdictions, they have already gone there, especially for disputes below $10,000. And what is used, of course, I will not go into what they call algorithms, but they have applications. There is an application called Fair Claims. That one is an online dispute resolution platform. It employs AI technologies. And of course, through the algorithm, it can process what is there. What really happened is they get quite a number of cases, and then they get the precedents. They analyze the facts. They get the precedents. Then they say, if in the fifth of these cases they decided like this, then the outcome should be like this. And these applications have been used by the judges. They help the judges to arrive at a decision. So some people are saying, maybe we can have 3 arbitrators, one of them being automated, that is autonomous. Others are saying, fine, let us continue with the human judge and the robot judge, or robot arbitrator and human arbitrator. The only issue now, I think, the areas which are concerning people are the liability. If they make a decision, an award, is it a product liability case or yes, because this is a product which was employed and it made a decision. Was it a product liability or it should go for an appeal? As they said, now the appeal goes to who? because to another robot, maybe 3 robots now. Yeah. So, because this has happened actually in the US for bail, issues of bail and rest. Someone was released on bail using these other programs. Of course, when they say the robot or the autonomous robot, rather autonomous judge or arbitrator, it is a program which has been programmed and it can go through all the precedents, all the data, all the whatever. So it made a decision. It released a convict. No, not a convict yet. It was just, they call them criminal defendants. So 2 or 3 days after, he committed the same crime on another person. Then this person didn't want to go, of course, he had no cause of action in this other ordinary thing. Just went for, says, the person who manufactured this, this application is the one who did what? Who caused my daughter to be offended by the criminal. And of course, at that time, that's when they asked the Chief Justice of the US, Roberts. He said, where are we at this stage? He said, we are there now. That is now a robot judge. For him, he considered and said, we are there now. In another case, still, this one was coming from court. The robot decided, let me see, what is it? This was product liability. This is a hypo. Hypo is also another program. I think you're aware about it. It guides the arbitrator. So if it guides the arbitrator can, using that program, make a decision. So there were also issues. In one of them, the other one was released on bail. In another one, they refused to grant bail. Now, the issue was, as they have been talking about, due process. When the algorithms were being made and all that stuff, I was not there. I was not given a chance to see what algorithms were done. And of course, that is a cardinal principle, fair hearing, due process. But so they went for an appeal. But when the judges looked at all the information that the system had, they found there was no other decision they could have made apart from what the other program had done. So apparently, we seem to be there. It is just that, as Mr. Kirunda has said, we just have to adjust. The programs are there. And in any case, in some of these other areas, like regulatory guidelines or arbitration, the AI, some of them are called autonomous arbitrators, computer-assisted arbitrators, automated. They are doing very well. And here in Uganda, we don't have antitrust cases. But those are huge cases with a lot of documents, e-discovery. We don't have discovery here. So that's why we are maybe thinking it is very far. But where you have huge documents, a lot of documents, precedents, the AI knows how to distinguish the precedents better than actually us. Maybe this is aside. In our courts, most of our judgments these days are probably per incuriam. Why? So if we had these autonomous, yeah, Well, if we want to make it an argument, I can still stand by that. But because they don't have access, actually. The judges don't know who said what and who didn't say that. We don't have those things. But if we had these other programs assisting them, they would bring to them, they would highlight these other precedents and say, look here, there was this, can use this. If you say this is wrong. And in those other jurisdictions, they have these are the what I've called juridice, fair claims, immediation, equibly. Those are programs which give the judges, actually they make the decisions. The judge just comes in to do what, to make a decision. So we're not very far away from an autonomous. We can say they don't have emotion, they don't have, but I can imagine Mr. Kirunda coming in, he's autonomous car. He was sleeping and then he's coming for an arbitration. What's wrong with having also a robot arbitrator? He comes in with a car which is driving itself, just presses. If he could trust his life to an then why can't he trust his the decision to some arbitrator? So we're getting to that. By the time we get to those flying cars, and I would, yeah, we would say, look here, let them decide. After all, I'm going to lose about how many millions, or I'm going to earn so many millions. So in my submission, I think we are not very far. It is just us now, the lawyers. We have to tune ourselves towards, actually the field is called prompt engineering. You must learn how to question the system. You must train it to answer the questions you want, to do what it wants. That is AI. And of course, besides the AI, Mr. Kirunda is very good at blockchain. In arbitration now, some people are using blockchain for the smart contracts, enforcement. Yes. So, I don't know whether I still have more time. I can continue? You have like 2 minutes. Okay. So if you merge, you see, when they talked about disruptions, what did they mean? They are what they call disruptive technologies. Now, the disruptive technologies are AI, artificial intelligence, Internet of Things. Internet of Things is when you sit in your sitting room and you have a movie on your phone and you want to cast it on the screen. So your phone is now working with the screen, the TV. So that becomes the Internet of Things. Then there is also blockchain. That is Kirunda's area, I know. Then the vehicles, the self-drive or driverless. And then there are other things, of course, so much has taken place in the health sector, medical. The robots doing all those stuff and everything like that. So if you combine now all these other disruptive technologies, you will definitely be into a robot. Actually, someone was saying that Chief Justice robot. So I don't know whether we're going to be having we'll be addressing them as arbitrator robot, or robot arbitrator. But the only thing is, I don't know at that time, will we be having trial advocates who appear before, or even the advocates are going to be robots? So that's where I think we are going. Maybe we can think about it. The lawyers we can get scared that, hey, probably, if we remain as the lawyers presenting before the robot, probably it is better. But if now the robot is going to present before a robot, we are gone. But we will not be gone, as per my first statement, that it is just another lawyer coming in to replace the other traditional lawyer. Okay, thank you very much.
Thank you so much for that. This is Doctor. Thank you so much for joining us. I'm glad that you were able to make time to join us. He raises an important point: immunity. In very many jurisdictions, not Uganda, arbitrators or neutrals have immunity. Are the robots going to have immunity? If a robot decides, makes a decision, is it also going to have immunity, the way judges have immunity, the way arbitrators have immunity? So my question to you is that with the increasing utilization of AI, what appropriate regulations and should policymakers have in mind as we embrace the inevitable, which is AI in ADR?
Thank you, Nora, and apologies for getting here a bit late. I wanted to start by saying a joke. I had been attending the session upstairs, and it seemed like no-brainer between fossils and renewables. So I think we're in the same debate. Do we go robots or keep the humans? I think most of the panel has addressed the issues of AI, so I'm not going to rehash the pitfalls, the risks, and all that, but I think Baba has touched on the issue of who bears the liability. I think that's also been the debate: who bears liability in a driverless car in case it gets into an accident or gets into any. And the question was, do we go back to the person who is remote controlling or who engineers this process? So likewise, that might become the debate. Ordinary arbitrators have immunity, just like another adjudicator, for what they do in their ordinary course of their work of adjudicating and all that. So now that will become a question: should the immunity extend to an AI issued award or mediation? Now I think going forward, I think this is something I think we need to be critical, and I think both Robert and Mohammed have touched on it, that we shouldn't be worried about whether we're going to be replaced, but we should be more concerned about how do we manage this process going forward. How do we, because at the end of the day, we might as well begin thinking that at the end, one day we might just find ourselves where the humans in the dock, where the humans as defendants and plaintiffs and everything else, the lawyer, the the judge, is all a robot, which would be really very interesting if humans were the ones perpetually on trial. But I think going forward, the regulatory framework will now have to align itself. What we have so far, just like we're doing with all the other regulatory frameworks or regulations to address online trials, address e-filing and all that, we might have to address that with regards to every aspect of AI-related adjudication. One of the things that means we'd have to look at the whole spectrum of what the arbitration or any ADR looks like, and then say, how do we adjust the regulatory framework to address that? So for instance, if we're looking at an award, normally we assume that the award will be given by a single arbitrator if that's what the parties have chosen. Now, if they have chosen that each of them will select an arbitrator, and the two arbitrators are appoint an umpire, do we get rid of those rules? Because now we're tasking that to be done by the AI system. We could still adopt that. Now, if you just want to, that the award has to be in writing and issued by a particular certain date. So all those rules will need to be reworked. I'm just thinking of two possible options, thinking of it from the perspective of ADR. If, for instance, one of the things that we have been thinking, even as a way of getting matters to court, because usually what happens is that you get a matter to court, then you begin thinking, shouldn't it go to mediation, shouldn't it go to arbitration if there was an arbitration clause. What if we could even short-circuit that process? And that's where people have been thinking, for instance, evaluative mediation. Now, that would be probably the kind of thing that would be a vehicle for AI. All that we are saying, look at this dispute, look at the facts between the parties, give the AI to do that, these documents, and assess the potential success of the dispute for party A. And if, which ordinary human beings would do that by looking at the documents and say, counsel, okay, client A, this matter you can't succeed, you will lose. Remember, this is, we could factor all those things, what the AI is supposed to do. The immediate ones they do is documents, arranging documents, capturing facts. And I think one of the things Robert pointed out, one of the things we shouldn't discount, and we must bear in mind, that any AI by its nature is what is called what? Machine learning. It learns. And at one point, we might have it to a point where it has really learned to its maximum. So as long as it has the capacity to learn, it has the capacity to adjust, and has the capacity to integrate new possibilities. So if we can have, and we remember each possibility, even we as human beings, we adjust the law. Each new invention or a new step we take, we adjust the law. So that means that the regulatory system would have to match the new advancements in AI. Just think now, we're already doing that. We're admitting electronic evidence, we're admitting all kinds of things. We're admitting e-contracts. Recently, some emoji was deemed to be a consent to a contract. we're discussing what the viability of WhatsApp messages as evidence. Although now I'm wondering, with people putting in these disappearing messages, what will remain of your evidence? But just think, just think what the regulation will be. So what we should be doing is to make sure that the regulation matches. And the reality is that if we can feed in, there are certain stages. For instance, if you are the interim measures during arbitration, can the AI do that? I'm looking at the dispute adjudication boards in construction, where most times it is straightforward facts. Did you complete a particular segment of the construction in time? What the materials, what the resources put in? So those are best figures. Can it be the one, those kind of things, can they be driven by AI? Well, basically, even if you put a human being, we'll also look at the figures and say you are wrong on this side. We're giving an award for this particular stage of the construction. So let's just, I think the regulations will have to match. So for me, again, as I would agree with everybody that we can't really discount. There are those things which, even I remember during COVID, one of the things people were objecting to online hearings was the fact that they couldn't get the cues, the demeanor. You couldn't be able to, as we lawyers, judges like to see that the accused is lying by just his actions. So those are things which I think would probably remain. We just need to figure out how do we work around them. How much work do we offload to AI? How much work remains for the human aspect? Eventually they will disappear. I was once told that if you look at everything that we're doing, that you can actually sit in the comfort of your home or your house and open a bank account without ever stepping in a banking hall. Run that bank account without ever being near a banking hall. So you can just imagine the opportunities that you could do even with resolving disputes. That you, even when the client is somewhere, you can engage the client, have the client submit the documents, have the documents fed into the AI, and you have a dispute resolution process. So there are opportunities that happen, but at the end of the day, I still believe that we as human beings need to learn. Because as it was pointed out that URSB is phasing out so many people. But that's going to happen. Even as lawyers, we need to be adaptive. We need to be able to say, and this is not just for lawyers. Studies have shown that by a certain point, I don't know which year, there's will be so many such jobs lost to AI. Now the question is, how do you adapt to the times of AI as a lawyer? Just imagine, as Robert pointed out, we're looking at floppy disks. Those days, how were we reading cases? You had to go to the library and fight for that one volume of a book. Now you can go onto the internet, type in the name, and it even gives you multiple possibilities and alternative cases. Now you are reading now cases offline, you are reading legislation online and all those. So just imagine what you can do, and you are still here as a human being doing that. What you can still do even when AI, because these are all elements of AI. Even when eventually you have interfaces of AI, there will still be a role that you can play. Now, AI is not going to write the regulations. We'll still have to do the regulation, the writing of the regulation. So we need to understand what is the space, what can we do in the ADR sector, and then what regulations need to be enabled. Because remember, all this is supposed to help you resolve disputes. And I think we all accept that ADR is supposed to be the fastest way of resolving disputes. So if we can even resolve them faster, all the better. I think that's just what I wanted to end with.
Thank you so much. And ladies and gentlemen, as I had informed you earlier, we were pressed by time. We were given 45 minutes, but we've taken an hour. So I'm going to request that we stop here. I'm going to ask my panelists to give their parting shots, and we'll be closing the session. I'm sorry we can't take any questions, but I had indicated before that if you have questions, you can share them with the ULS team, and our panelists will answer, and the answers will be sent to you by email. So I'm going to start with you, Doric. If you parting shots on the topic before us.
Thank you very much. I really enjoyed the discussion, and I really enjoyed all the comments. I thought that they were very interesting. I still remain quite optimistic. I think the name of the game in my mind is the question of how unsupervised we leave AI. And given how lawyers are known to be quite controlling, I just cannot imagine or fathom the idea that there will be an unsupervised, fully robotic adjudication. I think even when we look at the cars that self-drive, I think when we look at in practice, you can use it in a road where there are no other cars. But as the moment you have other cars involved, people just automatically start to feel that, what if I lose the control? And what if something happens? And I think that's the question for us humans to overcome. And if we can, I think AI could be a very powerful tool that could help us make our job so much more interesting. At which point, I think what you said, Robert, is really on point, that the whole dynamic will change. We will be asking totally different questions because we will be living in the reality that will be so much more, that will give more free time to address different types of questions where the regulations will change accordingly. So, thank you.
Thank you. Robert, please.
I was just, thank you very much, Dira, for those very sharp comments. I was just thinking back to a certain date in June of 2019, and I thought maybe this is where I wanted to leave it. It's about midnight. I'm sitting in a boardroom in Nakawa Business Park. We are organizing, this is the eve of the 2019 Africa Blockchain Conference. I was involved in both 2018, 2019 conferences. And we had worked vigorously hard to bring in Sophia the robot as a guest feature at the conference. And it's midnight the night before, and we've just reached a deal with the American company that owns this robot. And they've sent over the contract, and I have to review it and send it back to the guys in San Francisco so that we can then have them send us because the robot is on the plane, but they won't let that robot out of Entebbe if they don't have a signed contract, because they must make sure we pay. And I open, and you know those recitals at the beginning of the contract, Republic of usually the ones that are here will say Republic of Uganda, this whatever agreement, I think it was services agreement, dated this date, relating to the services of Sophia the robot. And I fell back in my chair and thought, hang on a second. I've been doing this a while now, and nobody ever taught me how to review the contract for the services of a robot. Not the company that owns the robot, but the services. I took a screenshot, and that was my first slide. I was giving a keynote the next day. That's where I started my presentation. And I had to, what does breach look like? That was 2019. I kid you not, I'm not making this up. My keynote is on YouTube. You can see the slide. I promise you, I've not made this up here. I was, as the young kids would say these days, my flabber was gusted. And the same thing applies to this whole discussion on AI. I think the more that you think about it, the more carefully you must realize that whether you like it or not, for some reason that you have absolutely no control over, somebody is going to build an AI model that's in some way, I mean, you didn't choose to not go to the banking hall. I hate banking halls. I hate filling out bank forms. I think it's good motivation to own a bank someday. I just hate the damn things. But as unsafe as it is that someone might actually sit, change passwords, and steal all your money, you still use the banking app. As unsafe as it is that your email could get hacked, you still send sensitive information via email. The idea that you will practice for the next 10 years without some AI tool. I like how Dr. Nuri has pointed out that we go to court today. I'm traveling tomorrow, and I had to go see a judge to say, I know there are rules about witnesses who can't appear physically, but my lord, can I appear online? And he said, promise me you'll have a stable internet connection. I have no issues. You go away. And that, colleagues, is the new normal. It just gets more complex from here on out. I think what we should be doing, or what I intend to be doing, is to spot the new opportunities. I can tell you one of them. Someone will audit AI. And I hope that when they come when they need a contract for their services, they'll come to me because I'll know what to do, right? But thank you very much, and thank you for having me.
So much. Senior Mohammed?
Thank you. I think all of you know how to play chess, or a few of you. And there used to be two people who used to play chess, Kasparov and Karpov. And that's when AI started. They contributed towards making that other playing chess with a machine. Yes. The first results, the computer could not defeat Kasparov or Karpov. Today, Karpov or Kasparov or the new ones who have come on cannot defeat the computer. Why? Because they have added in more algorithms. They, of course, the way it thinks to make all the moves and determines and everything. So even the champions, the human champions, cannot defeat the computer. So adding on what Robert has said, something is coming up. The boys are coming up with a lot of algorithms that are going to do what? To make that autonomous or robot arbitrator, but actually not only arbitrator, but judge. And that is where we are going. The time is actually now. Thank you.
Thank you. Doctor, over to you.
I think it's inescapable that we have reached this point. And for me, I think just my parting post is just to say that as lawyers, we need to begin thinking very seriously, just as we always think. I know most of us do practice and we just go on with the tail end of regulation, but I think we need to begin thinking seriously about regulatory frameworks for AI. And the sooner we do, the better. And we're very good at doing that. I was reading through the building code, and it's a massive document. But we have allowed the architects to tell us what should go into it. So I'm sure we can always get the AI people, the developers and all those to tell us how would we best regulate this artificial intelligence. So for me, we need to do that, but also be sure that aware that at any point we will still have a very big role to play. We just need to, how would I put it, reinvent ourselves as human beings in this new world. We can't hide our heads in the sun and think everything will remain the same and it will be okay. So let's put on our thinking caps. Even as we embrace the technology, how do we best regulate it? Thank you.
Thank you, Dr. Olivia.
For me, it's exciting how these robots are assisting us fast, that I don't need to take midnight hours reviewing documents and analyzing precedents. So I think for starters, it's to embrace the facilitation aspect of it, that now we can actually our energies can be left to deal with the real issues, the real complex issues. Let the robot give you, the different summaries, the analytics, the prediction, such that then my role is to now look at the real complexities in the case and align it to the facts that are different from what the robot or the algorithm would have discovered. So for starters, and then also in terms of very simple disputes, I think someone mentioned numbers, that if it's a numbers game and you feed the numbers into the system, why should I crack my head over numbers? Let the robot do that, and let me do that I can do best with analytical thinking as a human. So indeed, we must embrace it. And like Robert said, the engineers and the computer geeks are actually reinventing. So let's not let them leave us behind. Let's be part of the game and ensure that we benefit from all the advantages. As to whether we will be appearing before robots, I think let's talk about it next year. For now, let them assist us. Thank you.
Thank you, my dear panelists. I think it's clear from today's discussion that AI will continue to reshape not only all aspects of our work environment, but alternative dispute resolution as well. So the question remains, are the designs going to be able to meet the requirements? And how are we as ADR practitioners going to apply and utilize AI? I'll let you know that as someone who's in the industry, arbitration and mediation during COVID, they were the first adjudication practices that embarked on AR. They easily adopted to AI. All arbitrations moved online seamlessly. Within a space of 1 month, we had platforms that were helping with case management. So if you're going to benefit or be part of the alternative dispute resolution practice, you must embrace ADR. We have heard from our clients, and the last summit we had, the ADR summit, different stakeholders were clear to the lawyers that they have no interest in creating precedents. I have my industry somewhere, I have a dispute, my interest is to resolve the dispute and continue with my business. My interest is not like the lawyers, which is to create precedent. That is not their interest. And right now, what your clients are going to do is they'll come to you and give you a situation, and if you cannot resolve it quickly and efficiently, they'll move to a lawyer who can say, I have a system which can put in all the facts and tell me what are the likely possibilities. So if we do not take the opportunity to embrace AI, we're going to be left behind. So in addition to your ADR skills, which you need, and ICAMEC provides training, FYI, but in addition to those skills, please ensure that you learn as much as you can with regards to the different platforms that are being used. When I was preparing for this this session, I came across something, a new platform that is called New Era ADR. This platform is, it has taken, what arbitral institutions like ICAME, KEDA, and Praxis do, they've taken it online. So now they have arbitrators from across the world. They have mediators from across the world. So what you do is you give them your dispute and they resolve it online. You never have to see them, you never have to meet them. You would just pay the fee and get your award, or pay the fee and get someone to advise on how to resolve the dispute efficiently. So AI is not going anywhere, and if you're going to practice ADR, it would be advisable that you embrace it. So ladies and gentlemen, I would like you to join me in thanking my panel, who have given us a very interesting, fun discussion. Thank you very much, and thank you so much for staying with us. I didn't even think we'd have a full room because of the time that we started, but thank you so much for joining us and for making the time. I hope it was beneficial to you, and yeah, have a good evening.